Please be seated. Thank you, Mr. Now, I think the arrangement is that we'll sit through to 2 p.m. and then we'll Mr. Carter, do you wish to affirm or take an oath?
Take an oath, Commissioner. Thank you. I, Bruce James Carter, swear by Almighty God that the evidence I shall give to this Commission shall be the truth, the whole truth, and nothing but the truth.
Thank you. Ms. Thornton.
Thank you, Commissioner. Mr. Carter, you prepared a witness statement dated 22nd of October.
I've got my witness statement. I've got my career witness statement. It's in it.
Is that correct?
Correct.
It's in it.
And you have a copy of that statement with you?
Yes.
Is that a document bearing document ID number CRW.998.002.0994?
Yes.
And is that your signature on page 13 of the document?
I presume it is. How do I get to page 13? On my computer it's blocked out, but I did certainly sign it on that day.
Thank you. And are the contents of your statement true and correct?
Yes.
Commissioners, I tendered that statement with its annexure.
Thank you. The witness statement of Bruce Carter, dated the 22nd of October 2021 and bearing the identifier number CRW.998.002.0994 with its annexure is admitted into evidence as an exhibit.
Thank you, Commissioner. Mr. Carter, have you had an opportunity to consider the Crown Remediation Plan document?
Yes.
And do you have any comments on the Crown Remediation Plan or the program generally?
Yes. It's an extensive plan. My career has been involved in corporate restructuring and turnaround prior to me becoming mainly involved with non-executive director positions. And therefore I've had a long career in remediation programs, and this is certainly one of the most extensive ones that I've ever seen. For a remediation to be successful, there are a number of elements that are required. First of all, you've got to have a viable business, because if you can't push through financially, then you can't remediate. And certainly in the position of Crown, terrific world-class assets right across the country. And so from a viable turnaround, you have the base from which you start. The second part of any remediation is identifying the problems and acknowledging the problems. And that can often be the hardest part, because in many organisations there's denial that these problems exist. And in fact, that leads to resistance. And what would they know? They're the new people type attitude. In terms of Crown, I don't think there's ever been a company in Australia's history that's been examined more so than Crown. And anyone that doesn't deny that there's a problem here obviously can't read. So the first aspect of, after the viability, the first aspect of remediation and acknowledgement and identification of the problem in terms of Crown, which is a key part of any turnaround or successful remediation, is present. You then sit down and you work out where all the areas have got to occur. And that's what the remediation statement represents. And much of it relates to governance, to corporate culture, to the way that they do things. The plan itself, whilst being extensive, sits from the top and then is pushed down through the organisation. And so each part of the organisation will be responsible for a different part. And you have to create an environment where there's encouragement for that remediation to occur, same as any turnaround. And again, that's what's driven down from the board through the executives right down to the teller on the floor. And that's what exists here. You create an environment where people feel safe to talk, safe to change, and welcome that. And then the last part of it is to monitor, to incentivise good behaviour, which amongst other things is the remuneration, it's in the way that people are dealt with, the encouragement, the recognition of good. And in all of the turnarounds that I've been involved in, they are the successful ingredients. The remediation plan here is very large. probably the biggest challenge of this remediation plan is how much change there is. And when you have an organisation that's going through significant change, getting all the moving parts to work is something that you've got to watch carefully. So far at Crown, it seems to be going well.
And you've had a lot of experience in the past as being a director of a company. Have you had experience before as a director in implementing a remediation plan such as this?
Yes. Well, first of all, as an officer, where in my days of insolvency, I did quite a lot of turnarounds of businesses that were financially viable but just needed to be restructured. And it's not just financial restructuring, it's dealing with the culture, getting the right ingredients, getting the leaders in place is critical, and then pushing it down and getting everyone confident that it can happen. In terms of my non-executive positions, probably the earliest and biggest turnaround I did, which was of the work cover program where the South Australian government put me in effectively as executive chairman of work cover. The treasurer at the time said, Bruce, we either put you in as receiver or we put you in as chair. And a government appointing a receiver over their workers' compensation system is not a good look. So I was put in as chair with a brand new board and effectively restructured that over 4 to 5 years, cleaned out the management, changed all of the culture, and it was recognised by government such that I was then put into a senior position on the Executive Committee of Cabinet and brought some of these roles across government. So a number of jobs that I did for government. In terms of other turnarounds that I've been involved in, again, another government job, which was the Territory Insurance Office, the largest government-owned insurance company at the time. Many of the businesses I'm put in, there's an expectation that will be some of the skills that I bring to the table. And there's a business, Australian Submarine Corporation, which has a large employment here in WA. And in 2015, it was subject to ridicule in Parliament. And that was a very low point in ASC. We had an acting CEO at the time, big changes in management, and we had to effectively go into a remediation program in terms of culture, in terms of financial performance, and in terms with dealings with the many, many stakeholders we had. And literally every day I would get up and read the paper, a bit like Crown, and find out what the day would bring to me. And after 2 years, 2 or 3 years, we were described in Parliament by the then Minister of Defence, Christopher Pyne, as an exemplar as a government business enterprise. And a lot of that was driven in Henderson down here at down by Fremantle. So yes, look, this is what I do. This is what I enjoy. Some people find it a bit strange that you would enjoy these things, but it's what I enjoy and I get great satisfaction from it.
And do you have a particular view about the role of the board in implementing the remediation program?
Yes, the board needs to lead, needs to walk the talk, it needs to put in place appropriate leaders. It can't trespass into management, but it can't be divorced from management either. So it has to be quite visible and hands-on without, as I said, trespassing into management. So here you need like-minded people at the board. You need the board operating as a team, and we've got a very small board compared to what it was 12 months ago. And you need to be able to monitor. You need to be able to rely on your systems. You need to be able to get the framework into place to allow the people to deliver the remediation. You need to put the resources behind it. And one of the things about Crown is that it has the financial capacity to do that. That's not always the case.
And what's your commitment to the Crown Board and to the Crown remediation program?
Well, my commitment is to see it through. I mean, the best part of a remediation or a turnaround is when you get through to the other end, if you ever get through to the other end, because it's a continuing program, and you can sit back and say, we've done it. Now, I did that with ASC in 2018, and the day that was set in Parliament, I was pretty happy. I'm still there. Because, as I say, you've got to maintain the rage. And all that happens is that the bar keeps getting lifted and lifted and lifted. And the stakeholders, the various stakeholders then require the next level. And it's relentless. And that's part of the fun of being a non-executive director.
Thank you, Mr Carter. No more questions.
Thank you, Ms Thornton. Mr Futrell.
May it please the Commission. Mr Carter, my name's Michael Futrell. I'm one of the council assistant. Can I start just by a couple of clarifications in your statement? If you've got your statement there,
Yes.
paragraph 3, you make reference to a statement you provided to the Royal Commission in Victoria.
Yes.
I just want to ask you to confirm that it's document number CRW.998.001.0438. It should come up on your screen, but it doesn't.
Hang on, I think it just arrived.
I might be able to provide you with a paper copy. It might be easier.
No, I have it, Mr Fuster. 12 June 2021.
That's it. Yes.
Yes, I have it.
I just want you to, if you don't, it might be easier if I provide a paper copy to you because if you have a thumb through it. Do you mind? And
Thank you. Yes.
confirm that's the statement you gave to the Victorian Royal Commission.
So confirmed.
And can we take it that at least at the time the statement was given, the contents of it were true and correct to your knowledge?
Yes.
I want to come back and ask you a couple of questions about that later, but just to see if some parts of it remain your view today.
Yes.
Before I do, can I just ask you some questions about your, you've touched a little bit on your qualifications and experience in the evidence in chief you've just given. But you obviously have quite a bit of experience as a non-executive director and have done so since you obviously transitioned your career, if you like, into those roles. You're a director of AIG Australia Limited.
Yes.
And you were appointed in 2019. Is that correct?
Yes.
And that's a non-executive role.
Yes.
Do I understand that to be an Australian subsidiary of a United States global insurer?
Yes.
And is the parent company, is that the American Home Assurance Group? Is it?
Well, it's called AIG Inc., I think.
AIG Inc. And is that listed on the
New York Stock Exchange?
New York Stock Exchange. And are there any, just by way of the constitution of the board of the Australian subsidiary, are there any directors on that board who are also common with the parent company in the United States?
No.
So is the board constituted by any executives from the United States parent company?
Well, there are AIG executives on it. Australia's not big enough to have an executive out of New York on it. So what happens is we have an executive from Singapore on it. So it comes down into APAC. Australia, unfortunately, doesn't rate in terms of size to get a New York appointee on it. It comes down to APAC. So we have a board member out of Singapore on it, and we have our CEO on it, and 2 other directors.
And the other directors, like yourself, independent?
Yes. One's an ex-AIG employee, but now is no longer employed by them, and so is independent, but certainly has a long history of AIG, and another person. And I'm now chairman of AIG. That's different from the statement. All right.
So does that effectively operate as an independent, albeit subsidiary, independently of the parent company?
It relies. It works very closely with the parent company because it's a corporate model. So the people, for instance, the CRO and the CFO, they report into the Australian board, but they also report into the APAC boards. So, for instance, our internal auditor does work right across APAC, Australian Pacific region. So the Chief Risk Officer reports into London. So whilst it's an independent board, it is very much reliant on AIG, and we work hand in glove. with an insurance company, as you'd be aware, a key aspect of that is having a big capital base, and it's required to be kept locally, and that capital base comes via AIG, as does the reinsurance program. AIG is one of the largest insurers in the world, as you said.
Okay, and you're also a director of a company called Aventus Capital Limited.
Yes.
And you were appointed as a director of that in 2015. Is that
Yes.
Is that part of what is known as the Aventus Group?
No.
No.
Oh, well, I don't know what the Aventus Group is.
All right. So Aventus Capital Limited, does that have staple securities that trade on the ASX?
I beg your pardon. Yes, that's it.
All right. And you're also a director of Bank of Queensland Limited.
Yes.
That's obviously a publicly listed company as well.
Yes.
I think, is it correct that you chair its risk committee?
Yes.
And you're also a member of its audit committee, investment committee, IT committee and nominations committee?
Yes, but BOQ is a little peculiar in that the non-executive directors sit on each committee.
Right. So as a director, you're also on effectively all committees?
Correct.
And you chair the risk committee?
Yes.
You're a director of One Rail Australia?
Yes.
And you're appointed in 2011?
Yes. Well, may I clarify that? In 2011, I was appointed as a local director of Genesee and Wyoming Australia Limited, Proprietary Limited, which was a subsidiary of Genesee and Wyoming Inc., which again was listed on the New York Stock Exchange.
Right.
In that situation, there were 4 Genesee and Wyoming Inc. directors and 1 local director, myself. After a number of years, I think it was 2018, I was then appointed to the New York, the parent company board, where I remained for 2 years until Brookfield made a takeover for it. Once Brookfield bought it, Macquarie Bank, or Mirror as they're called, bought One Rail and asked me to chair that business. So through various iterations, I've been involved with that business since 2011. However, just to finish that, to update that, last week, that business was sold to Horizon, which is which is not in my statement, could only happen last Thursday.
Right.
Likewise, I had a big week last week. Last week, Aventus was also subject to a takeover bid, so it was a big week.
Okay, and so your role as chair of the board of One Rail, is it likely to continue for the time being, or is it
only till settlement, and in terms of which again is subject to, so probably 3 or 4 months, and in terms of Aventus, I've agreed to stay on that board, not as chairman, but for a short time for the transition. So I will come off that board, I think it's December next year.
Okay, now you mentioned earlier your role with the Australian Submarine Corporation.
Yes.
You're the chair of the governing body of that.
Yes, it's called a GBE, Government Business Enterprise, and I'm appointed by the Minister of Finance, who's the shareholder minister.
And you chair something called the ASC Committee for Future Submarine Negotiations as well, is that?
That was an ad hoc committee that existed at the time. It's in my CV. As you no doubt would see from the press, that relationship with the French has been ceased. But at the time, I led the negotiations to the extent that we would co-work with the French on the future submarine. As I said, events have overtaken that now that we don't have a relationship with them.
All right. And you're a member of something referred to as the Resources, Infrastructure and Investment Task Force. Is that a South Australian government organisation, is it?
Yes, that's a group of about 6 or 7 public servants that I've headed up since, I think, 2006, and effectively using my insolvency and commercial skills, I get used by the government to come in and deal with resource and infrastructure matters. So I did the negotiations and saw the legislation through on the Olympic Dam. I then went down and did a $700 million restructuring of Nearstar, and then I head up the negotiations for the government in relation to what's called GFG Group, which is otherwise known as the Wireless Steel Mills. So I chair that group, been pretty stable since 2006, and from a state perspective been very successful. It's transcended various governments, so Labor, Liberal, likewise Australian Submarines I was appointed under Labor, and then I was reappointed by Matthias Cormann under Liberal and reaffirmed by Birmingham. So they are across all the different political parties.
Okay, and you're a director of something, the Sage Automation Group Limited.
Yes,
That's a public company but not listed, is that
correct.
correct? And what's the nature of the business of that company?
It does all of the IT, for instance, on the highways and on traffic lights. It basically automates processes through your water systems, through your businesses, and it's just the upgrading to taking it out of human hands and automating it. So it's the automation of businesses does work right across the economy, based in Adelaide.
All right. Now, you were a director of Sky City until earlier this year as well, were you not?
Yes.
Okay, and then you were appointed as a director of Crown Resorts in August this year.
Yes.
After the probity checks had been completed.
Yes.
And since then, you've been appointed as chair of Burswood Limited, pending regulatory approvals.
Yes.
Although what are the remaining approvals? Are they for Western Australian regulator alone, are they?
Yes. So I sit on the boards of the Burswood nominees and the lower companies, but it's the public company that requires approval from the regulator here, and that's what I'm waiting for. All the others approvals have been received.
Right. And in the meantime, you've also been appointed as chair of the Audit and Corporate Governance Committee for Crown Resorts Limited.
Yes.
And you're a member of the Risk Governance Committee.
Yes.
Or Risk Management Committee. Something called the Safety and Sustainability Committee as well. You're on that committee as well.
Yes.
And you're also chair of the Crown Melbourne Audit Committee. Is that correct?
Yes.
All right.
As of last week.
Okay. So, having regard to all of your existing commitments, approximately how much of your, if you like, your regular week or month do you have available to devote purely to the task of being a non-executive director of Crown Resorts?
I have as much time as it requires. And look, I have a busy professional life, which I enjoy. I'm 63, my children have grown. I'm a widower, but I have a new partner. She has her own career. And this is what I do for a living. The requirements out of Crown have been quite extraordinary in terms of time, much larger than what I expected. Often the board meeting 3 times a week, 4 times a week, in between calls. And that's at a level that I've maintained. One would expect, however, once the remediation program becomes implemented, one would hope that regularises, coming back to the normal timetable and requirements of a board director. This time last year there were 12 Crown directors. Today there's 3. So again, the board, I don't think it'll ever get as high as 12, but one would expect there'll be some more people that will be able to participate in the workload. But as it stands, yes, the last few months have been not only getting up to speed with the business, I was familiar with the business, but getting up to speed with the numerous issues and meeting a lot. So I have not, trying to think, I might have missed one board meeting since I came on as an observer, and that would have been because of a conflict. And I reckon I've probably been to 30 It is quite extraordinary how busy this is. But I have no issues in being able to deal with it. And as I said, 2 of my boards have been subject to takeovers last week.
Okay, can I ask you some questions about the nature of the training you've received since you've become a member of the Crown Resorts Board?
Yes.
You've indicated in your statement that you've undertaken some online training modules.
Yes.
What was have you received any other training aside from, or briefings aside from the online training in the area of responsible service of gaming?
Yes. So I said there I've done some online trading modules. There were a couple that I hadn't done. I've now done them. So in terms of AML CTF, Steve Blackburn, I've had time with him. I've also had all the benefit of all the various papers that have come to the board. In terms of responsible service of gaming, and these are all concepts and issues that are familiar to me from my previous background, not just in gaming, well, obviously to gambling it is, but AML CTF. So I came to it with a good level of knowledge. I haven't been able to go to Melbourne and Sydney because of COVID, but this is my 4th trip to Perth in 6 weeks. So I've spent as much time as I can getting to know the business here. I've spent time with the lady that heads up responsible gambling. I understand the programs, what we're putting into it, the resources. So I have done my best to put a fair amount of time into understanding what it is that drives these businesses, and in particular, having been the chair of Burswood Limited, understanding what drives Burswood Limited. Fortunately, I've been here at 2 really, really busy times for Burswood, one being the football final and the other one being telethon, and watched this property heaving in terms of activity and reported back to the board that we should be proud as to the way it delivers its services.
Okay, just sticking with responsible service of gaming for a moment. You mentioned, obviously, you were familiar with the concepts from your time as a director of Sky City.
Yes.
Have you been able to form any view formed a view at all about the comparability between the responsible service of gaming program for Crown Resorts as compared to the program in place for Sky City?
In the 6th review by the Victorian Commission, they actually refer in about 3 or 4 places to the responsible gaming structures at Sky City. So there was a recognition of that regulator that Auckland was ahead of Crown at the time when that was issued. So it was a big part of Sky City, and certainly when I've come to Crown, since I've been at Crown, it's become a big focus, and there's a program that the board are very committed to. Now, the 3 pillars of this are having people aware of it, and then assisting, and then supporting. And they're pretty simple pillars. But then you have to put the resources into it. And they're building the new area over here. I went into the existing area. It's not very welcoming. The new area will be a lot better. They're putting more resources into it. And as far as I can see, and I've met one of the people in responsible gambling that was available when I was there. I spent an hour or so with them. There is commitment right through the organisation to improving work in that area.
When you say you've met, you're speaking there specifically about the Crown Perth property, the people responsible there?
Yes.
And you mentioned the report, the 6th report of the Victorian regulator. That was 2018.
Yes.
And is it your sense, and if you don't know, then you can certainly say so. Is it your sense, though, that the if the position in 2018 was that the Crown program was behind that of Sky City at the time, is it your sense it remains so, or has it caught up?
Look, I think it's caught up, and Steve Blackburn is going to be heading this up, and that's one committed individual, and it's a crucial area of any gaming, and I expect that this area, supported by the independent committee, supported by the regulators, supported by everything, we will end up hopefully being the gold star, certainly in Australia, but if not globally, on responsible gambling. And the commitment and the plans that no doubt have been before the Commission are part of getting those in place, are part of us being able to maintain and protect our social licence to have a gaming licence. So that's a long way of saying we will get it right.
All right. Now, I think you mentioned in answer to one of my earlier questions a reference to some AML CTF briefings as well. And again, I assume you have a high degree of familiarity with that framework from your time as a director of Sky City.
Yes.
And I presume also from your time currently as a director of the Bank of Queensland, you'd have some idea of how it applies to the banking sector as well.
Yes.
And so, insofar as your briefings have taken place, we're to assume though with Mr. Blackburn.
Yes.
And what has been the nature of the briefings as regards the Crown Resorts AML CTF program?
So the main training is in relation to AML and CTF and all the different aspects that it can present, whether it's customer, whether it's by source, whether it's by jurisdiction. So it's an awareness training and what you do. So that's a lot of the training, and that's first line of defence. That's what they get trained on, and that's really important. You then go to what Blackburn's putting in place, and he will be given and has been given the resources to put them in place. You elevate the systems, and you want to try and get as much of them automated as you can. Take the human aspects out of it. You still have to have the human aspects out of it, and put the appropriate resources at it. And that's what Blackburn's doing, and he's taken the board through that. We've got a Part A, we've got a Part B, we've got the similar programs that you'd expect to find in a financial institution. Right across the community, there's been an uplift in these obligations. It's a bit like occupational health and safety. 15 years ago, small issue. Now it's ingrained, embedded. AML, 7 or 8 years ago, was something that the financial systems and people like casinos were aware of, but certainly didn't have the systems in place to deal with. Part of the Royal Commission, the Banking Commission, provided the impetus for that to occur, and everyone has lifted the bar. And the fact is that you can't be in the system unless you've got appropriate programs now.
Okay, can I ask you, in a similar way to the fashion I asked you questions about the RSG program?
Yes.
Have you been able to form a view or an appreciation of the comparability between the AML and the approach of the AML and CTF risk of Crown Resorts as compared to the approach that Sky City had at the time you were a non-executive director of that company?
A lot has moved in the last 9 months. Sky City's AML program was a good program, but I expect that it would be a better program now. Again, it was iterative, we had the equivalent of a chief risk officer there bringing that in. So it was a strong program. It was regularly audited. In terms of the Crown, from just looking at the history of Steve Blackburn, this program has taken a sort of a leap up, as opposed to perhaps Sky would have done it on a more even basis.
Okay, so the question that I may have for you in connection with that is it the case that, again, from your experience as non-executive director of the Bank of Queensland, is the approach to AML and CTF risk in the banking sector somewhat more mature, perhaps, than it has been in the casino sector, in your experience?
Yes. Same situation. From a banking perspective, if you don't get it right, you get fined, you get shamed in public, and you have no choice but to get it right. And it's pretty similar to what's happening with casinos. And what is happening also is that there's a lot more systems coming in that automate it and reduce the amount of human involvement. And so the casino sector should be able to benefit from that. And by and large, Blackburn's a good example. You'll find that the people that are coming into the AML, CTF area in casinos primarily come out of banks. And that's where Blackburn came from. So it's much more sophisticated than it was. A lot of investment, but from Austrac, same expectations. One aspect of gaming, of course, though, is that once you get to the Australian bank system, you can rely on that system in terms of you don't have to audit. From our perspective, if we can identify it back to accounts from KYC and knowing your customers, and it comes from an Australian bank, you can rely on that system. Whereas running a bank is a lot more difficult. Running a bank is also easier, though, to get the information from customers, because if they don't give you the information, you close the bank account down. Whereas a casino, if they don't give them the information, you're just not allowed in. So that doesn't mean that the bad guys or women are going to be necessarily detected. The problem with AML CTF in the gaming system is that it's only in casinos. If you go to the pubs and clubs and other areas of gaming, these controls are not there. So a bad person comes, wants to put their cash into the casino, gets sent away because our AML CTF procedures are working. They walk down the road, not in WA, but they walk down the road to the pub and the club and they get away with it. So this sector will certainly contribute to reducing it, but it's something that you won't ever get rid of until part of what will help it is cashless gaming. That will help. But you've still got remitters. You've still always, I guess it's like anything bad in life, you'll always find people that are able to get around the system, but it's pretty strong.
You mentioned there, partly in that answer, remitters. Are you there referring to third-party money remitters?
Yes.
That are used, if you like, as an underground banking system in largely undeveloped countries? That you...
Oh, yeah. A lot of third world countries, but there's plenty of other remitters. And look, not all remitters are involved in aspects that are money laundering or of those things, but a lot of them are. And so the way you deal with remitters is you don't deal with them.
Okay. You've mentioned in your statement, and this might be, it's because it was signed some time ago, that on the committee, the People Remuneration and Nominations Committee has recently approved a program for training of non-executive directors, which you've considered to be appropriate.
Yes.
Given you have a quite, it seems, good background in responsible gaming and AML CTF, is there anything on the program, in your view, that you need to undertake?
Look, it's a constantly changing environment, and being refreshed with it is a good thing to happen. So and the other thing with responsible gaming is that there are new programs, new software, a lot of the work that needs to be done to better deliver responsible gaming programs is developing. And so it's always changing. When that program came down, I think that's a good program, but it's certainly by no means exclusive. So one of the key things, for instance, that a board of a gaming company the size of Crown should do is look around the world as to what's best practice. Hopefully the best practice is at Crown. But if it's not, you find the best practice and you bring it in. So you do it by going to the jurisdictions. And you do it by swapping people between or having relationships. So it's a constant upgrade of skills as the community expects. So I'm saying to you that program is a basic program. It's an important program, but I don't see it as exclusive. And it will extend beyond that. And there will be other aspects of Crown's interaction in the community that will require training.
And is it your... This is I'm directing my question here to the board itself.
Yes.
Are you envisaging that the board itself will undertake that educative process of ascertaining what world's best practice is in particular areas and bringing that back to the board at the board?
No. What the board will encourage executives to do is to bring back the opportunities, this happens on most boards, for board education. Now, board members may come up with ways of doing it, ideas, but ultimately it's for management to deliver a program for the board to opine on. But continuing education is an important aspect of every board, but it's particularly important when you live and operate in a highly regulated environment. You can spend a lot of money doing a lot of research, and what you want to do is pull the eyes out of the best research. So a good example, this is not responsible gaming, is, for instance, surveillance. Bad people are always coming up with different ways of cheating on the floor. So whenever you go to the gaming jurisdictions, you go and see someone that's that are Las Vegas or one of these places where there's more cheats, and they tell you the different ways that people are doing it. You bring these back to surveillance, you understand them more. And so it's responsible gaming. You go and see what other people are doing. And the whole concept has to be to bring Crown to the highest level. So if you find a system that should come into Crown and you say to the executives, why haven't we got this? You charge them to go and do it.
Okay, can I ask you some questions now more directly relating to the governance structure? I think you mentioned earlier in your evidence in chief you are familiar with the remediation plan.
Yes.
One aspect of that plan suggests that the implementation of a centralised governance structure is under a degree of reassessment. And do you have an appreciation of what stage the centralisation has reached and what is under reassessment?
Yes, at the moment we have a draft board charter, which I think the Commission has seen, and it's in draft because it's subject to taking into account all the different views that are there. But
sorry, can I stop you? The board charter you're referring to is that of
Burswood Limited, I beg your pardon, Burswood Limited Charter, and it's in a draft form at the moment. The day after it was approved, I think 2 weeks ago, as a draft. The day after it was approved, I sent a copy to the independent director we have here in WA, Marina Fuster, for her input. That contemplates that there would be one independent director, which is in this situation Marina, but the directors would be appointed by Crown Resorts Limited. So that is a pretty contemporary way of dealing with boards and centralised skills, centralised controls, and centralised ways of dealing with finance and all of these other aspects, and is consistent with my experience with subsidiaries, of which I've been on a lot, and parent companies, of which I've been on.
In the consideration of the, if you like, the composition of that board, that's to say the Burswood Limited board, has there been, and in developing the charter, the draft charter, was there any consideration given to whether centralisation on the one hand and composition of a board that has a minority of independent directors, is independent of either Crown Resorts itself, the Crown Board or the Crown Management, is an appropriate structure given the idiosyncratic nature of the Western Australian regulatory environment?
Yes, we've had that discussion. So let me come at that from two ways. Part of a centralised, part of the benefits of being in a large centralised group is that you've got the scale to be able to do the matters that we've just been speaking about, AML, gaming, teaching, getting the appropriate people, finance, all of the scales that enable things like Burswood to be built. So it's a contemporary way of dealing with it. The way that you get the local flavour is by having local board members. And again, that's the situation that is considered in Burswood Limited. And indeed, the situation I had with Genesee and Wyoming Australia Proprietary Limited, where I had a very large shareholder in Connecticut, and I was the independent director in Australia, and the reason, and in particular in Adelaide. And what they relied upon me to do was to be a good non-executive director, but to provide to them the local flavour, local operating requirements, engagement with local statutory authorities and the community generally. So that's a really important part of what a local director brings. Having said that, as Burswood chair, I would expect that I would inject myself into this local community as much as they'll allow me to, and living in Adelaide and understand that business. So it works. The situation works, and a lot of my corporate career has been that. Flip it over. If you have a board that is controlled by independent directors, I do not understand how you can discharge your fiduciary duties as a parent by pushing investment, by pushing controls, by effectively putting stakeholder investment into something in which you don't control. Now, what happens if the independent directors take a view that is inconsistent with the holding company, and you've put all these resources in there? Your shareholder is going to be pretty cranky. And indeed, the amendments to the Corporations Law at Section 187 recognised that, and the time that it came out was welcomed by the non-executive director community. So, it'd be my submission that indeed the Parliament of this country has recognised the tensions that exist between subsidiaries and holding companies and recognised that with the enactment of 187. Now, I know in Burswood Limited, because it's an old constitution, that's not reflected, and that there's our submission would be for the Minister to consider, amongst other things, changing that. And that's a matter that the Minister will make a decision on. But it's really important. As I said, I don't know, evidence has been given about this. Before Crown bought this place, and I came here before Crown owned it, it was at a level, and I think they paid about $700 million for it. There's about 1.5 billion's gone into it, and this, on a global basis, is an outstanding facility. The terrace towers are as good as accommodation as you'll see, and having spent time here, this is a wonderful part of Perth. Now, that's occurred in an environment where the parent bought their strength, their balance sheet strength, their skills, their controls and everything to Perth, in an environment where they did control the board. A parent wants to see its subsidiaries succeed, and that's how it delivers returns to its stakeholders. Likewise, all of the stuff that I've given evidence on, AML, responsible gaming, a standalone business will not have the ability to access the capital, both human and financial, on a standalone basis as much as a centralised model. So there are a whole lot of reasons that support the centralised model as reflected by that is the contemporary way in which business is conducted in this country and in most countries.
I want to come back to, there's quite a bit you just said in that answer, Mr. Carter. I want to come back to quite a bit of that. But
Okay.
Can I just take it perhaps piece by piece and start with one of the things you said, either in answer to that question or an earlier question I asked, was that it was important to have directors on the local company that had a local knowledge. I'm paraphrasing it, but that's the sense of it. And you have had, obviously, a degree of experience as a chair of other boards, and you will be, subject to probity, the chair of the Burswood Limited Board. Do you have a view yourself about the extent to which the Burswood Limited Board should have more than one independent director who is drawn from the local community?
Yes, you could have two, but the parent has to remain in control. So if it's three coming from Crown Resorts and two local, then the parent remains in control. So it would necessitate an increase in the size of the board. And I think it's important to understand that a local board and a board that I would chair of Burswood Limited will run it as a separate company. And I know that there has been criticism of that when I say separate company in terms of its governance. And I know that there's been criticism of that there was effectively lip service to Burswood Limited's board meetings. And again, I've discussed that with the board, I've discussed it with Morena, and I said, if you want me to chair this thing, I'm going to run it as an independent company, as effectively as a subsidiary, acknowledging our relationship with the parent.
All right. Now, just to deal with, I'm sure you have become aware this week of the recommendations of the Victorian Royal Commission in relation to the Crown Melbourne property. And one of the recommendations of the Commission there was that, in effect, Crown Melbourne would have a majority of independent directors. That's independent both of Crown Resorts itself and its management. What would you say to the possibility of a similar change being made in Western Australia to the legislative framework, so that became enshrined also here in our regulatory framework, that you must have independence of that nature?
Commissioner Finkelstein's findings are problematic. I don't know how you coexist with your duties under the Corporations Act in dealing with stakeholder investments. So I don't know how it works, and I'm yet to be shown it can work. If I'm an investor into Crown or a banker into Crown, and I then invest into a subsidiary that I can't control, and that subsidiary grows rogue on me, I expect to be criticised. In fact, I don't think I'll get the capital in the first place. So I don't know how practically it works. And I'm not saying it can't work. I'm just saying with my corporate experience, I don't think it will work. But if that's what is put before us, that's what we'll have to deal with.
Can I just ask you about what you mean by control? Because control can take different forms. So if I understand the way you've answered the question and you've given your view there correctly, you are attributing to the word control effectively by virtue of having a majority of either Crown directors, then Crown Resort directors, or Crown management on the board of Burswood Limited, you're able to carry the day, as it were, on the board by your decision-making process. You control it in that sense, controlling the management of the company. Yes,
but it's a separate company, so you are still subject to your obligations under the Corporations Act to act in the best interest of the company. And indeed, as you're aware, Section 187 is promulgated on that basis. So a properly run company won't have conflicts between its subsidiary and its parent. And having been in that situation many times, it's hard to see what that conflict would be. So it's a long way of saying I don't know how it works. Now, maybe smarter people than me will tell me how it works. But as it stands right now, I see it as problematic. I take, for instance, finance. You know, if you're going to borrow to spend 1.5 billion, how does the local company do that without the balance sheet of the parent? Will the banks lend money through the group if there's a chance that the subsidiary may go and do something that's inconsistent? I don't know. The answer is I don't know.
So just to stick with this idea of control, though, because obviously in the situation in which a company is a wholly owned subsidiary of another company, the parent company always has the ability to replace the board with other people. So it has control over the membership of the board. And in a normal context, the members of the company control the board in that sense by the vote in a general meeting. So when you say, you've said a couple of times that you don't see how they can control. They do have control in that sense as the parent company, do they not? Yes,
but correct. In one aspect that they can fire the directors, if that's what you mean. But if that occurs, if you get to that situation, well first of all, you may actually have a situation where decisions are made at the corporate level and are properly passed at board meetings, and then so that the decisions are made, and then the directors are replaced because the parent doesn't agree with them. But then by then the decision's already made. If you do dismiss those directors, then particularly with Crown, it will lead to a degree of examination and excitement as to why that occurs. So there is no interest in that occurring in any corporate structure. And as I said, I keep coming back to Section 187, which to me enshrines what my understanding of corporations law is in Australia, and it doesn't contemplate having independent direct. Now I know this is a gaming company and there may be different issues, but if you're asking me in terms of my experience in corporate Australia and contemporary, and in fact globally, as I said, in Genesee and Wyoming, they would have never let two local Adelaide guys or women control the destiny of their billion-dollar business, and neither would have the shareholders. So it's a long way of saying, sir, that I'm not sure how it would work.
All right. It would be the case, though, would it not, insofar as the capitalisation goes, the parent holds the purse strings in any event. So what I'm suggesting to you is that independence of the local board would not affect the parent's ability to control the capital flow.
Yes, that's correct.
And it wouldn't affect the ability of the parent company to impose a group policies and group frameworks that were subject to the subsidiary board's application.
Correct. So why would you give that opportunity for the dysfunctionality? I mean, the two should be consistent. And from the parent company and its various stakeholders, it is in its absolute interest for its subsidiaries to perform at the best of their capacity. But let's say, an example, I can't think of any conflicts, but let's say the two local directors outvote the parent company director and they decide to sell an asset. And that sale the parent didn't agree to the sale, and they say, well, too bad, we control the company, we'll sell it. Why put yourself in that situation? Now, when I say why put yourself, that's what our stakeholders would say, and the various stakeholders in the community, and that's what I don't understand how it would work. And when I say the stakeholders, it's the providers of capital. I mean, this is a $7 billion business, fronting to the shareholders and saying, well, we invested in such and such, and it went off on a path that we didn't support, but we couldn't control because we didn't have control of the board. I think that we would be subject to criticism. As I said, it may be that smarter minds than mine can work it out, but from the way that I have dealt with in the past, I struggle to see how it would work.
All right, so I take it then that your view is that wouldn't be a positive move for the West Australians framework for the reasons you've just given.
That's correct, but I would also give it in the background that Burswood Limited will operate as a much more standalone company than it has before. So there will be meetings in Perth. There will be the board agenda will be consistent with what you would find on a contemporary board agenda. There will be details on the Burswood Limited agenda that you won't find on the parent company. So let me think of an example. Some of the local changes to employment law, some of the key aspects of the operation of the business. So telethon, for instance, that's not going to get up to Crown Resorts, but it's a key marquee aspect that should be considered by the board because of its impact on Burswood's relationship with the community. So if you come to a Burswood Limited meeting, you will have all of the aspects that you would expect to find in a standalone company. If you then go up to the parent company, for those of you that are on the Burswood Limited, you're going to be reading some stuff twice. But that's, if you're reading material twice, c'est la vie. And that, again, in the Genesee and Wyoming situation, I was chaired the audit committee in Australia and did all of these, some of Australianised. I then go to Connecticut and I was on the audit and risk committee there. I'd read some of the material that I'd just chaired. And that's the way it works.
I want to explore something you've just said partly in answer to the question where you referred to, used telethon as the example of a local event in Western Australia with which there's a community interest. There's something that would be of interest to Burswood Limited, but may not be of great interest to the Crown Resorts Board. And you've mentioned a few times Section 187 of the Corporations Act, which I take to be a reference to the acting in the best interest of the company.
Yes.
So in terms of, in your conception of what the best interests of the company contain, I expect that the members' interests are one of those interests you have to take into account. You may take into account the interests of creditors or contingent creditors because of the nature of the company's financing, potentially. Do you see within the conception of interest of the company as a whole any, if you like, good corporate citizen or community responsibility as part of that conception of interest of the company as a whole?
See, I would do it reverse from what you just described. I say the board is there to protect the value of that business, and you do that by dealing with your role in the community first, with all the obligations, regulatory, community expectations. So there will be expectations within a small community like this of the way that Burswood should behave. And you bring that culture down, you protect it, you perform, and then the members' interests are best protected. So I say by doing your fiduciary duty, you achieve it by making sure that, particularly if you're a casino, which is only a small part of this business, you're operating an integrated tourist resort, which is what Burswood is. if you're operating that it is a good corporate citizen, and it comes to the community with the respect that it's earned, which is easily lost.
All right. Now, and this if you recognise that Burswood Limited, if you like, stick with Burswood Limited for the moment, part of its interests include, in effect, the interests of the Western Australian community. Is that not a reason for promoting membership of the board of Burswood Limited that may in fact have a majority of individuals with those interests closest to their heart?
Look, it may be that a non-executive director to Crown Resorts Board is sourced from Perth, so that you're not here to answer my questions, but to turn it around, whether or not that would make a difference. But I would say to you that I don't think it makes any difference. I mean, as a chair of Burswood, I want to see Burswood perform well. I want to work with Morena or whoever may be that director. I will rely on her. She's a highly placed and well-regarded executive in this community. I have friends in this community. I have a business I chair in this community down at Henderson. And outcomes like raising 64 million at telethon, which is quite extraordinary, Crown have to be there and part of that. And the way that it'll be a part of that is if it has good, strong local support. So I don't think you have to say I've got a WA address to be able to get to that position. By the way, getting to that position is entirely consistent with what the stakeholders of the parent company want. They want this. They want. Otherwise, why would they invest $1.5 billion here? They want it to perform so well that it raises the bar across the group. I would be disappointed if that an individual takes a view that they have to have a Western Australian address to cause that to happen, because I don't have one, and I'm going to cause it to happen.
Okay. Now, I take it you have some familiarity with the peculiar structure, if I could put it that way, of the Burswood or Crown Perth group.
Yes.
And you would understand from that the actual licensee for the casino is Burswood Nominees Limited.
That's the licensee. The licence sits in the trust, of which that is the trustee.
Yes. Without getting to the legal niceties, it's the owner of the licence.
It's the legal owner, yes.
Now, you are also aware, I take it, that effectively the employer of the various people who do the day-to-day functions at Crown Perth is a company called Burswood Resort Management.
Yes, because I'm a director of it.
And do you envisage, and you've mentioned, I think, in paragraph 48 of your statement that there's currently no formal mechanism for reporting matters from the subsidiaries to Burswood Limited. Do you envisage putting in place some sort of structure or mechanism for that taking place in the future?
Yes. Look, what we have to do is to have a look at that structure and make sure we comply with all the obligations that sit in the trust deed. This is not unusual, but what you wouldn't do is have a separate meeting of Burswood Nominees and a separate meeting of Burswood Resort Management, which happens to be me, and then I go and have a separate meeting of Burswood Limited. So what we need to do is comply with the trust deeds. It would be good to contemporise the documents that sit, because they refer to arrangements going back to the 80s or 90s that don't even exist in Australia anymore. And I'd expect that all of the obligations that sit with Burswood nominees, resort management, would be dealt with at the Burswood Limited board meeting. Obviously, we'd have to get legal assurance that we're complying with our obligations and duties. But once appointed to the Burswood Limited, I will be a director across all three.
All right. Now, to go back to some of the answers you gave to some earlier questions, where you were describing or the position you see Burswood Limited as occupying within the Crown Resorts group structure.
Yes.
And in answer to one of my questions, you may have said more than once that you were going to run this board as if it were a separate company with its local business. I just want to understand a little bit more about what that you conceive that to mean. And so, for example, does that involve, in your view, having autonomy and the independence to appoint the CEO of Crown Perth?
Okay. It involves input into the CEO. Ultimately, the CEO will be agreed to by the parent, but involves input into the identification of the CEO, but more importantly, the performance of the CEO. So performance, whether it's every 6 months or 12 months in terms of their performance, and giving feedback, understanding what their KPIs are, and again, across the top executives, you'd expect to have that feedback. And that's, again, entirely consistent with other subsidiaries I've sat in, because obviously part of the feedback you can give as being involved in a local board is how he or she is performing. A key part of that in a place like Burswood is how they are regarded in the community. And that requires local flavour. Again, people like Morena give that feedback, and it is part of what a parent should expect out of a local board.
And what about the lines of communication and responsibility? Do you conceive in what you're regarding as the modern corporate model that the CEO of Crown Perth would be reporting directly into Burswood Limited and Burswood Limited alone?
No. He would, or she would, in this case it's Lonnie Bozzi, ultimately reports into the CEO, which in this case is Steve, but he has a dotted line to me. So I would expect that he or she, in this case it's a he with Lonnie, I would expect to speak to him every week. I would expect him to treat me or whoever occupies my position as a chair that is kept informed of the business. I would be disappointed if I found out about operational matters from the CEO in Crown Resorts rather than the CEO in Burswood. So again, that's consistent with other corporate structures in which I've been involved in, where you have a remote, and I know Melbourne's not that remote, but it's pretty remote, a remote parent company.
And what of the nature and limits of the authority of the CEO of Crown Perth, who, in your view, do you envisage setting those limits?
Look, they'd be set. Normally you have a delegations authority that sits at the parent company and is pushed down through the group. The local company would adopt and respect that and have any input into it. So if we looked at it and said that's just impractical to have that level of delegation, or whether it's low or high, you give feedback back to the parent company. So look, what would happen is that you have input into the budgets, you have input into performance, you have input into the whole organisation. And between the parent company and the subsidiary, you agree as to how this business will perform. The strategic plan of the local company should be set by the local board because they have local interests. So you go away and you have your day of planning and you prepare a strategic plan, and there's a budget that sits under it, and then that fits into the parent. And that's the contemporary way it works.
And in that contemporary model, do you envisage that the CEO of Crown Perth would be able to take instruction and direction directly from the CEO of Crown Resorts,
Yes.
and that may not be instructional direction that has the authority of the Burswood Limited board.
Well, you've got to be careful that you don't trespass between the obligations of management and the obligations of the board. Steve McCann is management, and he will talk to whoever the CEO is of Burswood Limited and deal with management issues. To the extent that they deal with matters that should be considered at the board, policy, major material issues, then they should be brought to the attention of Burswood Limited. But this is a big operation and thousands of employees. So items that relate to operational issues would normally be dealt between the CEOs. And you rely on having the key part to the rehabilitation of Crown and the remediation, which we spoke about before, is having good people in place. And that's the key to any turnaround and transparency in what they do. And I believe that we've got good people in place. I believe that we're starting with a clean piece of, we can redesign what's happening and we are starting with people that really want to see this succeed. And so I'm comfortable that the relationship that you're going to see between the CEOs will be strong. If it doesn't, then you've got to change it.
Can I ask you something about, if you familiarise yourself with the Burswood Limited Constitution as it currently stands?
Draft Constitution?
No, as in the...
Oh, the Constitution, I beg your pardon.
As it stands today?
Sorry, I thought you were saying charter. I have read it through. I don't, if you ask me individual sections, I won't be able to quote them, but I've read it through.
All right.
Oh, here we go.
I only want to ask you at this stage about two of them. It's already up, it's all done. If we could scroll to page pinpoint 0010 and article 3.19.
Yes.
Now, you might recall you received some questions and topics that referred you to article 3.12, which I will come back to, but before doing so, are you familiar with 3.19 and 3.20, which is on the following page? If we could bring that up and put it underneath of it.
Yep. Yes, I've got 319 and 320. Commission of all notices. Yes.
Now, have you attended some meetings of Burswood Limited as an observer?
One.
Do you know if notice of the directors' meetings is being given to the GWC?
I think that meeting, which was in August, they did give notice. And I think through this process, Burswood Limited's become well aware of its obligations under 319 and 320. And certainly, as chair, I'm aware of this, and that's what will happen. And if the commission or the commission's nominated representative wants to attend, they will be welcome.
All right, that was you've answered the question I was going to ask you, is whether you were going to ensure that those provisions would be adhered to as chair.
Well, I don't know. It's an obligation under the Constitution, so it's a black and white decision. I have no choice. I'm going to comply with the Constitution.
Okay, you might recall you were provided with some topics for your statement. Mr. Carter, we could call up PCRC .0028.0028.008.
Yes.
I just noticed when reading through your statement that there were a number of these questions that were not directly answered, and I just wanted to know if that's because you don't know or there's some other reason.
Okay.
Could I draw your attention to this is pinpoint 0013 and topic 30.
Topic 30. Right. Yes. What?
Do you have an understanding of the role of the ERCC?
Yes.
And what is your understanding of that role with respect to the Perth casino operations?
Yes, it's ERCC. Historically, I understand, was created about 12 months ago by Keith Barton, whoever the CEO was at the time, essentially had all of the executives on its Executive Risk Compliance Committee. I've read the draft charter. It is being in a stage of iteration and change. One aspect of it, when I read it, was that needed to be changed is that the CRO should be on there, Chief Risk Officer. And I think under the proposed changes that would happen. So it's a risk compliance committee of peers, and you need Steve Blackburn on there, and you need the compliance officer on there, and you need the chief risk officer on there, and that would report then up to the board. So it's a group of first line of defence and the risk model, but at a high operational level, looking at what's occurring across the business, but it has the important input of having the CRO on there and also the Chief Compliance Officer. Both of those, I think, were going to be appointed in the August meeting, but the August meeting was disbanded because of the obligations of appearing in the commission. They didn't get around to it. So there's quite a bit of change that I think that would have to happen there. But at this stage, that's my reading.
All right. Now,
Mr. Carter does deal with it. It's paragraph 60 of his statement.
I thought I did.
yes, but it's the appropriateness and effectiveness and vision responsibilities component I'm trying to come to. So,
sure.
In Crown Melbourne, there is Crown Melbourne has its own audit committee.
Yes.
Is it audit and risk or just audit?
Just own audit, I think.
All right. Now, is there any? Do you see that to be a beneficial aspect of the Crown Melbourne structure?
Look, I believe so, but I have not been involved enough yet to be able to comment. I expect it would because but I don't know. I'll have to pass that judgment once I've been to a couple of meetings. If it doesn't add value, then it should be closed down. If it does add value, then the question that follows that, would it add value in Perth to have a similar one? And that's a question that is in my mind, but I want to get a feel for how the various audit committees interact. And I've discussed that with Steve McCann, that we may have to have a Perth audit committee. So it's on the agenda.
Okay, and can I take you back in this document to question 17 and ask you again. I can't detect there being any answer directly to this question, and it may be that you don't have the information available to you, Mr. Carter. But
Describe the degree of influence, direction. Well, I could look through my statement again, but I mean, the fact is that it has a huge influence. Describe your knowledge or understanding of the degree of influence.
Is it in the nature of the answers you've given to my earlier questions relating to the control aspect?
At a Crown Resorts level, it has a significant influence, and as I've said before, Crown Perth, Burswood Limited, will get the benefit of all of the programs, resources, skills that come down through the various subsidiaries, whether it's Crown Melbourne, Crown Sydney or Burswood. each of the locations you will take the experiences of those individual locations. This is what you do with the subsidiaries, and pull the best out of it. So it may well be that you have an experience in Crown Perth that is positive for Crown Melbourne, and you bring that back up. So it's not like Crown. You learn from your subsidiaries. A good example, Genesee and Wyoming, going back to it again. I established a risk committee at Genesee and Wyoming in Adelaide. In Connecticut, global company, they took the risk framework that I had in Adelaide and brought it into the parent because they liked it so much. So, and it was pertinent. So to say that what you do is you feed off each other, and the concept is that you bring, hopefully, it's a rising tide. You bring everyone up to the same level, and it just keeps going. So I'm sure that there are aspects of the operations in Perth here that could be implemented in Melbourne. And likewise, when Sydney gets started, it will go across. And as I said to you before, part of it is you go and look at other places, and you're always trying to raise the bar in terms of performance.
All right. Can I ask you about something you mentioned earlier, which is the proposal to alter or to introduce a charter for the Burswood Limited Board?
Yes.
And I think you mentioned that in your statement as well.
Yes.
The document I want to show you is CRW.701.009.5375.
Well, the one that's on my screen is all black.
Yes. That is because I think it's been redacted to remove privileged material from public screen and from the view of the Commission. So,
Okay, I've now got the front page of the charter,
yeah.
the draft charter.
So, I think if we could navigate to clause 4.1 on pinpoint 0.5381, I think we've already dealt with this, which is the composition of the board. And I think you mentioned it almost immediately, that you would have at least one, well, it requires there to be at least one non-executive director of Crown Resorts and the CEO of Crown Resorts. But you've indicated that essentially as a non-specified requirement, we'll have an independent director from Western Australia.
Correct. I could see here in 4.1D, I'm not sure you can specify that anymore anyway. Age discrimination, I think that's probably have to be deleted, but
Right.
The rest of it. And there's another clause in here which says that the meeting's to be held in Perth.
Yes, and so can I just, across the page, clause 5.1, and you may have already been directing our attention to this, Mr. Carter. This is on pinpoint 0.5383. There's a reference to subject always to the company's overriding duty to act the best interest of the company as a whole, etc. Is it working in a consultative, cooperative and in harmony with Crown Resorts?
That's consistent with my evidence.
And I think there's a similar sentiment expressed in 5.4 towards the bottom of the page, the second bullet point. Is that reflecting, I think, what you said earlier about the modern structure of where you have a wholly owned subsidiary?
Yes, sir.
And were you, in the course of the discussion about the Charter, also dealing with, or do you call dealing with, the proposed amendments to the Constitution?
Yes.
I think you'd mentioned that earlier. So that, if we could just navigate to 0.5389 in attachment 2. You may have seen more than one draft, Mr. Carver. This is the one attached to this memo. And I just want to take you to page pinpoint 0.5415. and clause 5.13.
Yes.
And I think earlier on you were indicating that you didn't see how effectively you could operate independently as a subsidiary board, and it may in part have been reflected in the proposed changes to the Constitution in this particular clause.
Well, this is pretty well consistent with Section 187 of the Corporations Act. So that's an example of what I said before, contemporising what's a very old constitution.
Yes. And so it's your understanding of this that, in effect, if the board of the subsidiary acts in the best interest of the holding company, that's taken to be the best interest of the subsidiary for the purposes of Corporations Act.
Yes. That's the current law as it exists in Australia.
Yes. And there's a little higher in the page is another clause, 15.16. It's not yet completed. And I don't know if there was any discussion about this one. Sorry, scroll down.
Oh, yeah, down the bottom.
And blow up 15.6, please.
15.6. Right.
So this is obviously a work in progress as things stand in this document. But I really want to draw your attention to 15.6C. And coming back to something we dealt with a little earlier in your evidence, Mr. Carter, this question of control of the parent. And here there appears to be a proposal, at least, to enshrine in the Constitution an element of control that takes certain decisions really outside the scope of the decision-making powers of the Burswood Limited Board, unless there's approval of the Crown Resorts Limited Board itself.
Yes. So my comment on that would be, first of all, this is a draft. Secondly, my understanding is that any changes to the Constitution require the Minister's approval, local Minister's approval. That approval, of course, will be taken under advice. There's nothing in here at the moment, but I'll give you an example of something that may be in there, would be you can't, any sale of a major asset. So this company can't go and sell the hotel for 600 million to someone and then tell Resorts what they've done. So you'd expect, and we actually haven't discussed what may go in here, but I would expect that they would be high-level matters of materiality, not fettering the ability of the board to act in a sensible manner.
All right. So then, just coming back to something you said earlier, then, insofar as the, if you like, perhaps the concerns of investors, if there were a higher degree of independence of the Burswood Limited Board, a provision of this nature could effectively remove any anxiety in relation to things like a described sale of the asset or other things that might destroy capital value, whilst leaving all other decision making in the hands of an independent board.
Yes, that's a hypothesis that would be inconsistent with contemporary arrangements, but that certainly would obviously depends what goes in there. I looked at it the other way, that it would be highly material matters, which is probably the same way. Yeah, I hadn't considered it in that respect, but I acknowledge your point.
All right. Now, is there any... well, first of all, I think you mentioned in answer to an earlier question that the current board directors of Burswood Limited consist of Mr. McCann, Mr. Bossy, and Ms. Fuster.
Correct.
And you will be a member subject to the probity approval.
Yes. As you know, it's a public company, requires 3 directors. Mr. Bossy was always an interim director, and because Crown lost all its directors, so it had to comply with the law. So what it had to do was have people that were authorised here in WA to go onto the board, and that's why Lonnie was put on there, so that we complied with our obligations. Lonnie will come off when I have my approval, subject to getting approval.
And has that particular arrangement been the subject of any discussion at the Crown Resorts board level?
Yes, it has.
And what of at the Burswood Limited board level?
There's only been one Burswood meeting, that was in August. I was an observer. Subsequent to then, I received my clearance at the Sydney and Melbourne and Resorts level, and subsequently I was asked to chair Burswood Limited. So I've had those discussions with Lonnie, who I must say back in August I'd never met. So it's been iterative, dealing with the fact that we've got so few directors, and of those directors it takes a long time to get approved. So it's dealing with the practicalities of getting through the approval processes. So Lonnie would come off when I'm appointed. I've had that discussions with Lonnie. I advised Morena when we had a meeting. It was like Sunday the 17th of October or something, which was formalised, and I advised Morena by email the following day of that position.
So the meeting on the 17th, is that a Crown Resorts meeting, was it?
Yes, if that was a Sunday. And then that's where we approved this draft charter. And it was that. But no, that's where, yes, the draft charter was approved and the suggested composition of the board was approved. My announcement as Burswood chair had come shortly after I was cleared by the regulatory authorities, and we worked out who was going to go forward in terms of the board. Because as you recall, we had a board member retire, being Tony Karanis. So we were down to three directors.
All right. Now, you've indicated in answer to, I want to take you back to the Constitution,
yes.
The current Constitution, which is clause 3.12. I think you're familiar with it. This is the one that refers to Burswood Limited having its head office in Western Australia, and you've indicated in your statement that you consider that to be either to be compliance with that provision of the Constitution. I just want to ask you, in practical terms, where the governance structure of Crown Resorts is centralised effectively in Victoria, and as you've mentioned, there is this aspect of control of the Burswood Limited board for the reasons you've said. How do you consider that Burswood Limited is able effectively to comply with that part of the Constitution?
Because that's with central management and day-to-day control or exercise subject to the policies and input of the parent. So we will have our board meetings here. We will have local input from Morena, whoever, the CEO will live here, and we'll have centralised supply of some services, but the management team will be here. And there'll be aspects of the Crown that will never get to Crown Resorts of the Burswood's operation because they're too small. and they're issues that are more properly dealt with at the base level, at the subsidiary level. As I said, in my view, consistent with. So my view is that we will comply with 312. The draft charter has 4 meetings a year. I probably think we'll have more than that. I think we'll have once a quarter, probably, plus another one for strategic planning. That's what I'd normally do on a subsidiary.
And you think that's an adequate number of meetings per year to run Crown Perth?
On formal boards, yeah, you're getting quarterly accounts. But if you need to have more, then you would. I mean, as I said, I think I've had 30 at Crown Resorts. So you react to the environment in which you are. If you're not getting through the business properly, then what you do is you have more meetings. But generally, quarterly accounts. So I would expect in between times to get monthly accounts, but you wouldn't have to have a board meeting to look at them. So most companies I'm on where we don't meet each month, you would get quarterly, you get monthly accounts. They get put into Diligent, you have a look at them. You might get a one-pager out to the directors as to how the performance is.
Do you foresee there being an active role of the Burswood Limited in oversight of risk management?
Yes. The Burswood Limited will be important to look at the RAS, the risk statement, all the parts of the risk management framework, which you're familiar with, and to look at them how they apply here, to look at them if there's any breaches, trigger breaches or breaches of the RAS, and then also to bring their local flavour. Now, what happens in a risk statement is you have it at the high level and then you push it down through the organisation. So, again, part of the Burswood board would be making sure that it's got... So, by way of example, the person that is in charge of all the cleaning, they should have a risk assessment of that area. So it will be inflammable, it will be occupational health and safety, and it will be all of the issues. Now, you don't want to see that at resorts level, you probably don't want to see that at Burswood level, but that's what a good risk framework does. It sets the tone from the top and pushes it down, and that's why you'll often see it shown as a triangle. And so there's levels of embedded risk all the way through. And the whole concept of risk is for it to become embedded in the organisation as occupational health and safety is now. So therefore, it will be driven at Burswood. Burswood would look at different things. So, you know, it might have more of an interest as to the patronage at certain parts of the assets, let's say the theatre, compared to what Resorts is really concerned about. So it brings a really important local risk aspect to it, and it's consistent, again, with the other businesses I'm in.
In terms of setting a tone from the top, and by top here I mean Burswood Limited.
Yes.
Reviewing the risks and management of risks once a quarter, do you consider that to be an adequate and sufficient demonstration of setting the tone from the top on risk management?
Yes and no. That's what happens in most companies. You don't do it every month. But if you're having a lot of... Well, first of all, if you're embedding the system and getting it as part of your culture, you may need to meet more. But what happens is on key risks, if there is a breach, either of the trigger or of the limit, then it'll be brought to the board's attention at that time. You wouldn't wait for a quarterly. There would be very few... I can't think of any businesses I'm in that would look at it more than quarterly. But again, this is not... it's fluid. And if there are issues with risk, then they get brought up to the board. If you have to have a risk meeting or you have to have issues that need to be raised, then you call a meeting.
What is your understanding of the mechanism then in the Crown Perth structure for what we might term an ad hoc event? So something has triggered a
breach,
and it's something you consider ought to have been brought or ought to be brought to the attention of the board. What's the process, to your knowledge, of that occurring in Crown Perth?
Yeah, look, I think from a practical perspective, it'd probably come up through the RCCC. But if people are doing their job properly and there's been a breach, first of all, hopefully we saw it coming, but I'll come back to that in a minute. The CRO's been advised, the Chief Risk Officer, the CEO's been advised, and it comes through a level. Now, there'd be some stuff that you wouldn't need to set a board. Let's say, for instance, there was a breach of the number of cars that are allowed in the driveway. I'm not particularly interested in that, but I'm interested to know that it was safe. So again, there's a degree of judgment that would come up through the ERCC, and again, it comes back to this issue of having embedded culture to the mitigation of risk. A good example so I apologise for continuing my question. A good example where you may have a risk breach that wasn't even on your radar is cyber. So let's say you have a cyber attack and your systems are down and you didn't know it was going to come in. So that's a good example where you're expected to be elevated to the board. Yeah.
So what's the mechanism in place for Crown Perth for that to be elevated to the board?
There would be a report to the board.
From whom?
Probably the CEO, might be joint CRO, CEO, depending where it comes from, maybe out of the ERCC. Probably the CRO, because it's their responsibility, but you'd expect the CEO to be all over it. And I'll tell you that I also would expect the party that puts it up to put to the board, which the board may or may not accept, how it's going to be fixed.
And is your understanding that process is recorded in some form of risk management documentation, or is that just an expectation you have based on your understanding of how that...
No, there's a risk management framework in place.
Okay. Can I just put to one side for the moment the question of what Article 3.12 means in the Burswood Limited Constitution?
Yes.
And ask you a more general question about whether or not you consider that, whether from a good governance perspective, the responsibility and, if you like, the direct responsibility of the directors that control the operations in Perth should be reposed in the directors of Burswood nominees as opposed to Burswood Limited.
No, they should sit. There's a recognition of... It's not uncommon to have subsidiaries or have a corporate structure. And in the case of Burswood Limited, it owns the shares in Burswood Nominees Proprietary Limited and owns the units in the trust. So from a practical perspective, and it's well recognised in corporate law and corporate practice, that you have it in Burswood, unless there's something in the documents that says otherwise. In some older documents that may exist, if you can change it, you change it. But the practical aspect of it is that the people that sit on those companies are the people that are going to be involved in Burswood Limited. Good example is me.
So do I understand from that, effectively you're saying that the responsibilities of the licensee can be discharged through Burswood Limited as its parent company?
Yes, subject to... I say that is subject to receiving advice, specific advice from our legal advisors, that is consistent with the documentation and that establishes these trusts, the trustee and the various regulatory aspects. Now, when you deal with gaming, there's a whole bunch of different pieces of legislation and regulation, like there is in a lot of life, but in gaming in particular. And I would want to have it well understood that is the way that it could be practically done if it is not able to do that, then we adapt to what needs to be done to comply with the documents.
Thank you. Can I ask you some questions now, back to the topic I think we began the day with, which is remediation?
Yes?
And the remediation plan. You outlined in your evidence in chief your overview of what the plan is and its comprehensiveness and so forth. Is there any aspect of it that you consider to be, if you like, addressing the most serious or acute, if I could use the word deficiencies, in the Crown Resorts systems and structures?
Well, most of it. I mean, the AML CTF systems that Steve Blackburn's bringing in, and all the people that will come behind them, there's sort of an army coming in, that will address part of the key weaknesses that have been well publicised. So you've actually got it from two ways. You've got it, because no more junkets. So you've got the causes of the problem are being reduced, not eliminated. And on the AML side, you have a high level of systems being brought in and people to bring those in as a second line of defence. Likewise, responsible gaming is fundamental. And again, issues like disparity between pay, resources, recognition of the importance of those people is being elevated to where they should be. So the problems are the causes of the problems are less, they still exist. And the solutions or the remedies to those problems, remediation, the resources being put into that are enormous. And Crown has no choice but to get it right. That's why I'm sitting here, because it didn't get it right.
What about culture? Do you see culture as a feature of the
Absolutely.
Things?
And culture, you've got to have the people to want to do this, or if they don't want to do it, then you've got to find people that will do it. And you can have all the tools in your toolbox, but if people don't know how to use them or respect them, then it's not going to work, although making it automated helps. But, I've had a good look at the Deloitte Culture Report, and I looked at it, and I first of all, I tried to get it into perspective. And they make a significant comment in their executive summary in the first page of the second paragraph, where they talk about the moment in time when this culture survey was done. And it was at a time which was pretty dark in terms of COVID, lockdowns, pretty dark in terms of every day you pick the paper up and these people that you respected as your leaders are being belted from pillory. And then you find out about all these things of this organisation that you work for that are not good. So it was a dark time, and Deloitte recognised that. I then went and looked at the basis under which Deloitte looked at their questions, and they gave 11 questions. 1 elicited a positive response, 7 elicited a negative response. So it was biased. I'm not saying biased in a bad way, but it was directed, is a better word, towards eliciting the problems that existed. And I think we ended up with 545 comments that came out of that. A lot of those comments related to their perception of being let down by their leaders, to being embarrassed by going home and saying, "Oh, I work for Crown." So, really interesting piece of data. Another interesting piece in there was that 92% across Crown, I think it was 89 in Perth, believed that they had a role in compliance and doing the right thing. So you've got a basic, and I think it's something like 90 or 85% believe that the way that they do their job will impact on the result for Crown. So what you have is a core of people that understand their role in compliance. Now, that's not that easy, actually. A lot of people, compliance can be seen by people as an obstacle. and it's just a nuisance that gets in the way. So at 92%, that's about as high as you can get. So to me, the environment that we've got to work with in terms of the culture is really conducive to being able to get this turnaround. And it needs to be led from the top. And if you don't, and as I said before, no one can dispute the need for this to happen. All you have to do is pick up the paper. And so denial, which is often a part of something that prevents cultural change, can't exist. And if you have someone that's denying won't move, then you move them. They leave the organisation. And the last thing I'd say is what we're asking of our people is to behave to the highest level of integrity, to care, to take care of each other, to provide great environments for people to live. And that's the easiest thing to do in a job, is to perform at a level where you're told, do your best, maintain your integrity and be a good person. And that's what the Crown people are being asked to do. I'm not going back to the past, but 92% believe, according to Deloitte, in a study that was done in a very dark time for Crown, they understand their influence. And the other reason I went to the Deloitte report is I actually spent a lot of people in Perth don't even know who I am. So I sort of wandered around the staff and talked to them. I couldn't do that in Melbourne and Sydney because of COVID, but I went around and talked to them. And, you know, it's rare to find someone that's been less than 2 years or 5 years. There are lifers there, and they love the place, and they deliver great service. So I'm very confident that when you go to them and say, these are these are the 4 bases under which we continue to exist to provide great experiences for our people in a safe environment, that they will say, we can deliver that. And that's what they do. So that's a long way of saying I've read the Deloitte report.
Yeah, I appreciate that. Thank you for your answer. I've got a couple of observations to make about what you've just said, though. And the response that you've identified and highlighted about compliance was tempered, though, wasn't it, with a statement to the effect that the majority of staff believed that it was necessary to bend rules and work around policies and procedures to get the job done. And it was driven by a perception of customer centricity and a profit mandate. So it was even in that context, there was a negative aspect to the conclusions in the Deloitte report. Would you not agree with that?
Absolutely. And telling people to compromise their integrity or not do the right thing or work around it is not a very pleasant place to be. And that's my whole point. When you take that 92%, you say the guts of it is there. What we need to do is what you've just put up here. Do the right thing, work together, act respectfully. We're passionate. Nowhere in there does it say we must achieve the greatest profit that is available under working these assets, and if there are problems, work around them. That is not the culture that the new Crown will be, and it's not the culture that's existed for the time that I've been there.
All right. So, leaving aside the context in which this culture report review was undertaken, you've mentioned all of the, if you like, the mitigating factors you could think of. In spite of that, it does still reveal some quite concerning indications about the nature of Crown's culture, at least at the time the report was undertaken.
I totally agree. And that, as I said to you, an important tool, important piece of work. But like anything, you've got to take it in the context it was in. But it provided to us a pathway, which our new people are dealing with, on how do we change that culture. You don't always get that pathway. So that's the importance of the Deloitte report. And there's no naivety about it. This is going to take some time. And we've got to find out ways to measure it. and we've got to do culture surveys, and we've got to do risk culture surveys. All the financial, all the banks and all the financial instruments have been doing this. Most businesses are measuring culture, and if we get our culture right with these assets, we will deliver to the community what they expect, and we will get this right.
I think the transcribers might need a break, Mr. Carter.
Can you give us an estimate so we can plan for the
About
afternoon?
30 minutes for me.
30 minutes?
Or possibly less.
Beg your pardon?
Possibly less.
Right. What do you think? 30 minutes? We take 30 minutes now? I think we might take a 30-minute break now, which we should comfortably have you away before your aeroplane leaves without you. So we'll come back at 2:30.
Thank you, Commissioner.
All rise.
Thank you, Mr. Carter. Mr. Petrel.
Please, Committee. Mr. Carter, just before the break, we were dealing with the Deloitte Culture Review. And would it be fair to say that from answers to the questions, some of my questions, and essentially from, I think, what you said in your opening statement, that you accept there's a need for cultural change within Crown Resorts Limited?
Absolutely. Not a need for. That change is occurring as we sit here.
And does that need and is that change extending to Crown Perth?
Yes. We've employed an executive, Tony Weston, who has experience in cultural turnarounds and improvements, and the whole of Crown will be subject to that work. So in terms of Crown Perth, and it was individually dealt with in the Deloitte report, that information there provides us the roadmap on what needs to be done.
All right. Can I take you to the statement you gave in the Victorian Royal Commission, which is CRW.998.001.0438.
Yes.
And I just want to take you to there's a series of topics and answers under two headings. Known Crown failings is one, and future is the other. I appreciate that this statement was given at a time when you had really only just arrived.
Yes.
But I think it might be fair, these appear to, if I might say so, I summarise some of the things you've also said to the Commission today. If we look at what is said in paragraph 39, the last sentence.
Yes.
Does that remains essentially true as of today?
Yes.
And 41, just read that and then confirm that's also accurate.
41.
Paragraph 41 of your statement.
Yes.
And 42, I draw your attention to that one as well.
Ah, right. Yes.
And 43, I draw attention to that one and just confirm that remains the change.
Yes.
The case.
Yes.
You agree with? You're saying that 43 remains the case today?
Well, 43 is referring to my position in lines 41 and 42. Require massive change, which this was done some time ago, is occurring as we sit here, and elimination of any blockages to such change, which is entirely consistent with the evidence that I've given today.
That's right. So I just wanted to ask you, I wanted to confirm it was essentially a summary of more or less the same things you said today. But I want to ask you about that phrase you've used there, elimination of any blockages to such change.
Yes.
What do you have in mind or what are you meaning by that?
Okay. Could be a variety of things. The Deloitte report talks about workarounds and controls or processes that get in the way of doing their job or allow them to do their job poorly. So there must be an environment of being able, encouraging people to speak up and to identify what are the blockages that prevent them from doing the job. By way of example, I never report that particular incident because I've got to sign out 6 bits of paper and then do a whole bunch of reports. It's too hard. So a better way of doing it is X, and that then causes the process to be followed more. So there's processes, there's people. If there are people in there, as I gave evidence earlier on, that just don't accept the need for change, then quite frankly, they have to go and find another place to work. So there's that. There's providing people with the tools to change. So if something can be done easier and make their job in compliance or whatever with some more software changes or processes, then we've got to look at investing that. The whole thing is to encourage them to be able to get to where we want them to be, which is as described in the aspirational cultural change that you had up on my screen earlier.
Can I ask you some more questions about, I'm going to coin it as shape up or ship out. Essentially, you said, described, I think, on a number of occasions, that if people are not willing to make the change, then they've got to find another job, or use words to that effect. Is that another way of putting that in order for true cultural change to take place in any organisation, not just Crown Resorts, you need to have essentially an attitudinal change throughout the organisation? You're nodding.
Oh, yeah, I've agreed with you.
And obviously there's been a good deal of change at the board level for Crown Resorts, and a very large degree of change at the senior management level as well in recent times. Do you see part of the cultural reformation of Crown Resorts as including the next layer of management as well, as in the middle management?
Yes, I mean, I said it the whole way down. It's a bit like occupational health and safety, or attitudes to diversity, or harassment, or any of these things. You know, you comply with what's required, or your performance is subject to review. Now, I would hope that in the environment and the corporate culture that we are leading from the top, that most people will embrace it. Because we need people to run these businesses. And getting people in this country at the moment to run these businesses is very hard. So I would hope that they will see a clear pathway. And to me, the average human does want to act with integrity and do the right thing. So to the extent that they felt compromised because they were driven the profit at all costs, and we take that away from them, then that should enable them to do their job. Now, if people behave in this manner, we will actually maximise the performance of the company, because we will protect its assets. We will have the place in the community that we expect to be. And again, we were discussing some time ago, you bring it from the bottom, you bring it from the top. But I mean, I don't welcome people to the casino. I don't serve them drinks at the bar. I don't take the rubbish out. I don't do all of these things. All of that, the interface between Crown people and the public is very large. And you're only as good as your weakest link on this stuff. And so as I said, you're always uplifting it. So if we find that there are blockages, yes, then we'll have to deal with them. Now, if that means re-education or changing their roles, or they just don't fit, then so be it. And quite frankly, if they won't toe the line on the culture, they're probably not going to be happy enough to work for us anyway. So that's easy for me to say as the director up the top, but that is the support that we'll give. Now, there'll always be challenges, because humans are humans on the way through. But if we take someone that's problematic and we say, what can we do to get you to where we want you to be? And if it's change my desk, or give me more tools, or give me a car park, or just say thank you to us, then that's what we'll do. But that's the path we're on. And it's not inconsistent with most turnarounds and cultural turnarounds that I've been involved with.
Well, I want to ask you about that, because I think you've indicated earlier today and in your statement that you were, the most relevant of the evidence would appear to be the significant program to turn around the performance of the ASC Corporation, most comparable, if you like.
Yes.
And you described in answer to that question a lot of things that are positive steps that can be taken to bring about a cultural change. Are you able to explain to the Commission how the Board of Directors can and will contribute towards bringing about that, if you like, that holistic change to the organisation?
Yes. In the ASC situation, it was a unique situation because a comment was made in Parliament that the government wouldn't trust ASC to build a canoe. And the impact that had on the workforce, where we had a couple of troubled programs, was quite detrimental, apart from being unfair. And you're a worker, you've been made a mockery of at the highest area in the country, and so they dropped their heads. So we went from board down and said, we will prove them wrong. We will turn this business around. And it was integrity again, integrity in the way we did work, manufacturing, and we deliver at all costs. And if blockages are there, we move through them. And within 2 years, we got to a place that no one would ever thought we would have got to. And we are at the world's best practice and have been for 3 or 4 years. So again, it comes back to pride. It comes back to providing the tools and the ability. Key to it is getting, as we've already identified, sir, getting the right people on the way through, and having the leaders that can bring those changes. And even you'll sometimes lose leaders because, notwithstanding they might have been able to do it, you just actually need to change. It's a bit like a football club. You can't win because the matches aren't so good, so you sack the coach. And it's always remarkable how you've sacked the coach and all of a sudden the football team starts winning with the same players. So it comes out with it's a leadership, but then you push it all the way down and you measure it on the way through. So what sort of things will we be measuring it? We'll be looking at all of the different aspects of our AML, our responsible gaming, we'll actually look at our turnover, our people through the door. One of the reasons people come to Burswood is because it's safe and because it's a great place to be. A lot of them never go near the casino. So we will gauge it by places of a place. People will judge us by turning up because it's a great place to be, and that's what we exist to do.
Do you have any concerns about the scope or adequacy of the remediation plan?
No, but yes, I'm sorry, I withdraw that answer. Yes, the size of it, but the pace at which it's happening at the moment it's going very well. But again, it's a dynamic document. It's going to have to be adjusted for what came out in the Royal Commission last week. It'll be adjusted for the findings of this commission. It'll be adjusted. It'll just be continually updated for what life presents to Crown.
So would it be fair to say that, if you like, the concern you have, I don't want to put words in your mouth, is essentially the size and dimensions of the change, what has to be done? Yeah,
and so we will measure it, and we will get the best people that we can get to deliver. And quite frankly, that's what's happening now.
And do you have any concerns about the ability of the current team that you have in place to deliver on a remediation plan of as ambitious as it is?
Are you talking Crown Resorts or Burswood?
Crown Resorts.
No, but you continually assessing and looking at how individuals perform, particularly when you're a new director. Some of these people, I've never even met them because of COVID. And once I meet them, I'll be in a better position to make my own assessments as to whether or not they're appropriate. COVID has made this really hard. I mean, Perth's been great because I can come here. So that interaction that trying to get to know these people and what their values and skills are outside of considering documents has been severely restricted by COVID. It's something that once the borders down, I will, I'm sure my fellow board members will rectify.
So to sort of summarise the answer, is that at the moment no present concerns, but you have not yet had enough interaction to form a final view.
Yes, it's a dynamic role. And in organisations, I'm not speaking about Crown, I've had situations where people that appear to be doing a great job today, within 6 months, you form a different view. And our people get paid a lot of money and they're expected to perform.
And if the question were rephrased and directed purely to the question of remediation, implementation of that component that specifically applies to Crown Perth, have you any concerns about the management team in place there to deliver on the remediation plan?
Well, the CEO is Lonnie Bozzi, and to me, he is doing a very good job in difficult circumstances. He is a very experienced gaming executive that's been with this company for a long time. It is actually hard to find good gaming executives on a global basis. It's even harder to find good gaming executives that would be capable of being licensed in this jurisdiction, and it's a small pool. Lonnie has a long set of experience. He is a passionate Western Australian, and as far as I can gauge, is well regarded in the community. So the workings that I've had with him so far have been strong, but Lonnie, like every other executive, by the same token, like every other board member, is subject to continuing review as to performance. And I've been on boards where board members haven't performed within 6 months and have gone. So, a dynamic institution will be continually uplifting and monitoring performance. But as Lonnie sits at the moment, he is an excellent CEO. And then you go down through the group, and it is a stable group of executives delivering a quality product. If aspects come up about people's behaviour, then you assess that as you go along. It's no different from any organisation. But as he sits here, he has my support.
Okay, I've just got, I guess, a similar question to one I asked earlier in the week to another non-executive director, which is, taking into account all that you have already on your plate in your various other roles, what was it that made you accept this particular role with Crown Resorts at the time you did, which was obviously at a time of some turmoil for the organisation?
Well, first of all, this is, believe it or not, this is the type of work I like doing. Secondly, you could see actually what has to be done with this business to turn it around. So come back to how my evidence, I looked at it, the aspects that I always look at in a business, and you could see that the path to turnaround was evident. This was before the Melbourne Royal Commission. There were aspects that came out of the Melbourne Royal Commission of which I was unaware. And I must say that was a pretty interesting time. You'd pick up the paper and find out about stuff about your own company that you didn't know. I could have pulled out at that time because I was still through on the basis that I was not properly briefed. To be fair to the board at the time, they didn't know a lot of the stuff, so they couldn't have briefed me. But I could have pulled out at the time and said that I didn't have this information when I said that I'd join, and I didn't. I'm committed to seeing it through. Once we move through the Royal Commissions and have taken into account everything that we're required to do, we then start to consolidate the work that's underway at the moment.
Okay, I just want to return to a topic I omitted to ask you about earlier, Mr. Carter, because we dealt very early on with the idea of responsible service of gaming.
Yes.
I just want to ask you a couple of remaining questions I have on that topic, which is, you would be aware that in the AML CTF area, Crown Resorts is undertaking an enterprise-wide risk assessment for money laundering and terrorism financing risk.
Yes.
Do you consider that in the area of responsible service of gaming or harm minimisation associated with gambling, that there may be benefit undertaking a similar kind of risk assessment, and as say an enterprise-wide risk assessment of Crown Resorts operations?
In relation to responsible gaming?
Yes.
Well, I think, I mean, we've got a program that Steve Blackburn will give evidence on where a lot of that is happening. And we've got an independent committee that's providing input. They have been quite, I guess, complimentary of what Crown's doing. There are challenges in how you monitor a lot of this. So we could take an enterprise-wide assessment on the risks of it. But I would argue that to some extent a lot of that's being done now. Whatever we can do to be one of the world's leaders in responsible gaming is what we should do.
So perhaps I need to explain what I'm meaning when I say enterprise-wide risk assessment. What I'm asking you is whether there's a process underway which you're aware for identification of the specific risks associated with the delivery of gaming services to customers that present a risk of harm.
Well, that's the I'm not sure I understand the question, but that's the basis of what we're doing with responsible gaming, and bringing in the various controls of that. I mean, if you look at gaming, I think our independent experts said about 90% of people that game, there's no issue. That's their findings. And there's about 10% that have issues, and they're varying issues. It's no different from many things in the community, like alcohol is a good example, or drugs, or the various aspects of decisions that people make in terms of those and how you reduce the harm of them. And I've got to say, the casinos in this country are the best places to game. Are the safest places to game. 40%, just under 40% of Australia's game. And it's not casinos, it's sitting at home betting on the sports, it's down at the racetrack. It's playing poker with your mates, it's betting on the price of iron ore. So Australians are gamers. I'm not, by the way. And if you take Perth, it's probably the safest jurisdiction in terms of gaming. It's the only jurisdiction I'm aware where EGMs are confined to the casino. And in my view, you've got it right. The day that you take them out, they will be a proliferation and they'll get into the pubs and clubs and you'll never get them back. And the reason you never get them back is because the party that benefits the most from them, being the government, because of their taxation haul, will never allow them to come back. So where you've got them at the moment is the safest place to have them, and allows and you know, you take pubs and clubs in other jurisdictions, they cannot afford to, let alone have the appetite to have responsible gaming like we have. We're the only place that can do it because it costs a lot of money. So when you talk about harm minimisation, it would be my submission that in terms of gaming, the safest place you could be is on that gaming floor, because there's a whole lot of people around there trained to look out for awareness, to support you, and to approach you and then support you, the three pillars. Go to a leagues club or a pub, sit at home, watch the money go, football, bet on the next goal. Any of that, it just doesn't exist. So we will strive to improve that, and we will improve it. We'll probably lose customers because they'll go off into the unregulated place. But we have to look at us our stakeholders and say we still give a great experience, but to that small group to which it becomes harmful, we have to do our best to remediation. And as you know, that can involve a number of things, including exclusions and assistance and all of those things. But what we're not, sir, is it, which exists in other jurisdictions, is someone that goes home to their suburb, which exists in virtually every other state, and with their pay packet on a Thursday or Friday night, and he or her go down to the local pub and blow it on poker machines or on those things. If you want to gamble here and you live in an outer suburb, you have to make a genuine effort to get there. And once you get there, you're in an environment where you're subject to, you're about as safe as you can be. But the fact is, gambling, at the end of the day, the house usually wins. That's how it's able to build these things.
But focusing on the 10%, let's focus on the 10% who ultimately may or are at risk of developing a harmful behaviour.
Yes.
In terms of the process of harm minimisation, to your knowledge, is there a process being undertaken to identify, if you like, the specific delivery of the gambling services that affect that risk? In other words, are there ways you can deliver your services in a way that minimises the possibility that the 10% will develop a problem?
Look, there are various controls that can come up on a machine that tell you you've been gaming for, if you talk about EGMs mainly, aren't you?
Well, EGMs is one area.
Yeah. So EGMs where you can say, stop play after a certain amount of time, sign saying up you've lost this, you can have your own. We've got a thing called Play Safe there, but it hasn't been taken up because it's voluntary. It's getting that fine line between people's rights to be of freedom and make their own choice to protecting them against themselves. And there's not a lot of evidence around the world on it. And there's not a lot of studies. That's what I understand why Crown's gone to this independent group of 4 academics to find it. But it's my view, and it's the view of the board, that we will be duty bound to see what we can find. And that's why I go back to education a couple of hours ago. If we can find something in Timbuktu that is good for responsible gaming, we'll seriously look at bringing this in. But the fact is that if you game, there is a good chance that you will lose your money. That's what gaming is. The other thing I'd say, sir, is that the strength of an integrated gaming resort, which is Burswood, is that it's not always in your face. So you come to the towers here, it's actually hard to find the casino. You can go to the theatre, you can go to beautiful restaurants, you can go and have a drink at the bar, you can go and sit at the pool. If you want to find the casino, it's down the other end. So again, if you're looking at the temptations that exist, they will always exist in a resort if it's integrated and has all of these other aspects. Again, people don't necessarily have to go to the casino. It's a bit like a pub. You want to go to a pub and you go there to have a drink. If you go to Burswood, you don't necessarily go there to game.
Okay. Now, can I just ask you some questions around the structure of the RSG program?
Yes.
And as I understand it, Mr. Blackburn is the most senior executive with the responsibility for the RSG program.
Yes.
And his expertise predominantly lies in the area of financial crime.
Yes.
In your view, is there merit in appointing a person who has specific expertise in the area of harm minimisation to have the leadership role in Crown Resorts for that program?
Again, as a general comment, I would say that if we came across the world leader in responsible gaming, like you would in any organisation, we'd seriously look at whether or not we could access that skill. But you do that in any organisation. If I've got a group of executives and I've found someone that will uplift the whole skill base, I will move my executives around, and I've done it. In terms of Steve Blackburn, who I think she had to give evidence, or I may have, he is one committed individual and one smart individual, and this is important, but it doesn't require you to have the training of a physician. What you have to do is to have the training of knowing how to put systems through, embed it, bring experts in as you know, and get it down through the organisation. And that's what Blackburn will do. Having said that, as I said to you, if a responsible gaming expert walked in the door and it could raise our levels, we'd be duty bound to look at that person. But as it stands right now, I have the absolute confidence that Blackburn will deliver. And to the extent that we've got to give him the resources, we will.
He does have an enormous amount of responsibility when one looks at your remediation plan.
He's getting an enormous amount of people underneath him too. So he's getting what he wants at the moment. But you're right, we need him to stand out above and look at the policy rather than get lost in the weeds and the detail, and that's why he's getting the resources.
Just in terms of setting the tone from the top, aspect, in your view, is housing the primary leadership for that function in the same person, sending the message of that responsible service of gaming has the same priority as everything else that's within the remediation plan?
Well, you're giving it to a senior executive. The two senior programs that we have are AML and responsible gaming. He knows how to implement it. He's got the respect of the organisation. So as it stands right now, I think it's appropriate. But and the dynamics of the structure are, if it doesn't perform, we'll change it out. We'll change it. Nothing is cast in stone. And that's, by the way, one of the benefits of two things. One, having a broad church of boards, and two, being a new person in the board. You can ask the dumb questions, you can ask the questions challenging the status quo, and you can bring into being your experiences you've got across other places. We will see how it goes, but right now he's doing a good job. If it doesn't work, we're duty bound to review it.
Thank you, Mr. Carter. I've no further questions.
Thank you, Mr. Futrell. Do we have any counsel not in the room? Right, are there any applications from this room? No?
Just a couple of questions. So I understand that your view is that the Burswood entity should be rationalised and essentially Burswood Limited should be responsible for governing the Burswood Casino at the local level, so to speak, as opposed to the group level. But can I just ask you about the current situation where Burswood Resorts Management Limited employs all the staff at the Perth Casino, but doesn't appear to have any income, and it has no agreement with Burswood Nominees Limited to provide it with income to pay the staff or to do anything else. Is that a desirable structure, and is that what is going to continue, at least in the short term?
Commissioner, it's a contemporary structure and consistent with many companies in which I've been involved in, where you will have the workforce in a separate company. I'm not sure why it was set up like that in the first place. I'm all for simplifying structures. So if upon review it seemed inappropriate, then it can be modified. But the fact is that that is our business, it's our people. If upon review there's a weakness in that and the advice is that we should have agreements between the two to protect the directors of, for instance, the company that has no income, then maybe we need to do something. Having said that, I'm on both sides. I've been protecting myself. But it is quite contemporary to have your workforce in a separate structure. Often has been set up historically because of industrial instruments or because of arrangements. I don't know what happened when Burswood Limited existed when it was a standalone public company, but it probably goes back to that time. But yes, if it's part of a structure that should be simplified, we should do that, provided we don't in any respect compromise the position of the staff.
Burswood Nominees Limited and BRML have had in the past purely executive boards, that is management boards. You're now on both of those boards, I understand. Do those boards report up to Burswood Limited or to CRL?
Up to Burswood. Well, they don't, as I was giving evidence before, they don't have a separate reporting structure per se. They are part of the consolidated group of Burswood Limited. But Burswood Limited owns the trustee company, and which is the licensee, the legal owner. No, not the legal owner. The legal owner, and the beneficial owner is the trust, which owns the assets plus the licence. So the units in that trust, as I understand, are owned by Burswood Limited. So they're 100% subsidiaries. So again, and I think this is historical, the way that it was set up was, as I've just described, in running Burswood Limited, I will need to get good advice that we're complying with any obligations of any trust deeds. And if it becomes cumbersome, we'll look at the opportunities of streamlining it. But the fact remains that it is the group that runs that structure, and then Burswood Limited is owned by Crown Resorts.
So am I right in thinking that what you're saying is that those boards report up to Burswood Limited and through Burswood Limited to CRL, or...?
No, they just go as far as... Well, those boards don't report.
No,
they don't have separate board meetings. So there's no reporting per se. Their business is dealt with in the Burswood Limited. So that's where the assets sit, and they're the assets that we utilise in the operations of the business. And to the extent that that becomes a total business, that's what goes up to Crown Resorts.
Another topic, should Burswood Limited have board committees?
Yes, I don't have a firm view on that. Crown has got a lot of committees. And as I gave in my evidence, it may be that Burswood Limited needs to have an audit committee. Once we get into a routine of dealing with these board meetings in a more contemporary manner, that will come out. Now, whether or not that has to become an audit and risk committee, that is a possibility. Yes, I guess that's work in progress, Commissioner. I'm not saying it's not in, but I could see good reasons for it to be in.
Now, the Victorian Royal Commission recommended that the executive of Melbourne Casino be independent of CRL and report only to Melbourne Casino licensee. Aware of that?
Yes.
Am I right in thinking that model is not consistent with your proposed model for the Burswood entities?
Yeah, you're correct.
How would management of the Perth casino work if that recommendation was implemented in Melbourne? As currently, as I understand it, the CRL executives, it is certainly proposed that they should continue to have management or roles in supervising at least the Melbourne casino executives. And if that should change, would that then have a flow-on effect to the model in Perth?
It may do. I actually don't know how that model will work. And it's not something that we've considered at board yet. And once we get into the detail of what is expected by it, or what's recommended, but ultimately what the government require of us, we can look at it. But it would be illogical not to look at changes in Melbourne to the extent whether they should be mirrored in Perth. But as to whether or not they occurred, I can't comment because I don't know what it's going to look like. The model coming out of that out of the report last week is quite new and is something that we've got to get our heads around because we don't have it yet.
Having regard to your experience in the casino industry, what should be the nature of the relationship between the Perth casino and its regulator?
Respectful. The regulator basically controls your business and your destiny. So in other places where the regulator, and it's not just casinos, I live in a highly regulated, a lot of my boards are in highly regulated environments. You have respect. You hopefully have an opportunity to discuss, consult, and get to the right result. Absolute transparency, and you put them and you go to them with problems, and you've got to have a relationship that's working because it's so important. If they both go to their own corners and don't work, then a lot of this comes to a grinding halt. You can't get anyone approved, you can't get any changes, and there needs to be trust between the parties without compromise. So would I go out and have a beer with one of my regulators? No. So that would be a professional relationship, and that's just fundamental to operating in these environments. And at the end of the day, if the regulator tells you to do something, then you'd hope you'd have an opportunity to make a submission and have a sensible discussion. But if they ultimately say to do it, you've got to do it. Otherwise, you lose your licence or your licence compromised. So it's a little bit black and white, but it's in the interest of the community to have a working relationship.
Thank you for that. Only one other area. Don't know if you're across as yet the role of the Problem Gambling Support Services Committee in Western Australia, which is the committee which receives funds from gambling operators and disperses them to provide support services or counselling services to people affected detrimentally by gambling. It's currently funded and administered by the gambling service providers, including the Perth Casino, as well as receiving some government funding. Do you have an opinion as to the correct model in this regard? And first, should an industry wide, that is gambling, that's the gambling industry we're talking about, provider of services for problem gambling be funded by the gambling industry, including the casino?
I've not studied the structure that exists here, but I'm familiar with such structures. So, for instance, in New Zealand, they have a similar structure. Well, that's a matter for, I guess, legislators to decide, but it would seem sensible that those that are causing the issue should end up paying for minimising any damage that may occur. So your hypothesis is entirely reasonable, and that's the way I would expect it to go. Maybe all the pubs should fund Alcoholics Anonymous, but this is quite easily identifiable though to a subset of, particularly in Perth, a subset of institutions that are involved in that. So I apologise that I've not had a chance to look at it, but conceptually what you're saying would appear abundantly sensible and consistent with what happens in other jurisdictions.
And then having regard to your experience in other jurisdictions, do you think that industry participants, that is the providers of the gaming services, and in this case the casino, should be the ones to administer the fund, to fund problem gambling services?
No, there should be a degree of independence, but you certainly want them at the table, because they were the ones that will help you, not just the casinos, but it's all the other gaming areas, push it down into the places where this is where it's needed. But I would have thought there's got to be a degree of independence.
Thank you, Mr. Carter.
Mr. Carter, I want to cover a couple of the matters that have already been canvassed between you and Commissioner Jenkins, but I'll do so from a slightly different angle. And the first one is the question of board committees at Burswood Limited level. That's the first topic. What is your view on this proposition, that if Burswood Limited is properly to carry out the full suite of governance responsibilities that it should have, that really a board of three might be a little bit small, and perhaps it would benefit from the addition of perhaps a second Perth-based non-executive independent director, and I understand that would mean, under your model, perhaps an additional executive director as well.
I think it's unlikely that there'd be an additional executive director, an additional non-executive director.
But associated with Crown Resource Limited.
Yes. If we're not achieving what we need to achieve pursuant to our board charter, then you've got to adapt it. That's what happens. So, Commissioner, the establishment of committees is usually a way, as you'd be familiar with, for taking some of the work out of the board so the board can deal with better things like strategy and some of the other aspects that take its time. So that's quite often the reason why committees exist. It may well be that we end up with an audit committee here. I've not been through a period yet of financial statements and how it works. Another possibility may be the establishment, for instance, of a risk committee, but not forever. Maybe it's there until we can get sign-off. Bear in mind that our risk management strategy is externally reviewed every 3 years, our framework, until we can get a sign-off that it's embedded in the organisation and we can adapt it. So a modern organisation will try and delitter what's on the board if you can push it down into the committees. And it's just another way of dealing with it. So what you're saying could quite possibly occur to allow the proper running of the business.
And the reason why I join in that exchange, the question of size and committees, is because ideally you would have your non-executive independent directors on the committees, would you not?
Yes. The normal course would be you'd have one of your non-executive directors chair, for instance, the audit committee. The guidelines for AIDC is that you wouldn't have the chair doing that.
And would you see it as potentially advantageous. That sort of a system is potentially advantageous because it would allow the non-executive independent directors to become more embedded in the organisation, particularly when the organisation is in a state of evolution.
Yes, exactly. But by the same token, if we're able to get through all of that business in the Burswood meeting, then we could do it that way. But from transparency point of view, and just from the appropriate use of time of our executives as well as our non-executive directors, I suspect that there's a high chance that what you describe will occur.
And the second area that was canvassed with Commissioner Jenkins relates to the I think what was termed the rationalisation of the existing structure. I understood you to be saying that in your view, even under the existing structure, there's no real impediment, no practical impediment to the obligations and responsibilities of the licensee effectively being governed through Burswood Limited.
Commissioner, that's my practical view, but with the caveat that if there's anything identified within the trust deed that means that we're in breach of the trust deed or any of those aspects, then we will need to adapt to the rules of engagement. But assuming that it's allowed under the current documentation, then your description of my evidence is correct.
Can I put two things to you that might impact on that? The first is that Burswood Nominees Limited and Burswood Resort Management Limited are both parties to the state agreement.
Yes.
Burswood Limited is not. So the responsibilities, the direct responsibilities, are owed to the people of Western Australia by Burswood Nominees Limited and Burswood Resort Management Limited. That's the first thing. And the second thing is that Burswood Nominees Limited as the trustee and Burswood Resort Management Limited as the manager have specific identified obligations under the trust deed. So given that, does that cause you to reflect at all on your view that there's no real practical impediment to the obligations being effectively governed through Burswood Limited?
That may cause me to change the view. As I said, whatever's required in the structure is what we have. Another way of dealing with it is should Burswood Limited become a party to those agreements, and so therefore have the mirrored obligations so it becomes a party to the agreements that you've just described. So their obligations to the state are common amongst the companies.
Right. Now I've got two further questions for you. The first one relates to the proposed addition of a new article in the Constitution, 15.6, which deals with reserve powers. And you, in an exchange with Mr. Futrell, that was covered. And you said that that the content of the reserve powers hadn't been discussed at the board level, but in your view, they'd be matters that were had real materiality, I think.
Yes, Commissioner.
Now, I can think of one, maybe, major capital expenditure that might be a reserve power, perhaps with a ceiling. Can you give me, and I know you've said it hasn't been discussed, but from your understanding now, can you give me other examples of things that might be highly material and which therefore might be included in a list of subjects to be covered by the Reserve Powers Clause?
Yes. A decision to resume allowing junkets into Perth. A decision to scrap major programs out of Perth. a purchase of assets, agreeing to a widespread enterprise agreement with the workforce that has a knock-on impact through the balance of the workforce. So all material issues, they may not necessarily be financially material, but they may be policy material. And so that's, Commissioner, just in response to your question, there's some examples. As I said, it's not been discussed at the board. So and again, involvement with commissions such like as this is other matters where we will consider when we take them forward. But it would be that sort of stuff that I just described as examples.
All right. Now, my final question to you, I'd like the witness statement perhaps displayed, and it's at pinpoint 1003.
Oh,
It's the first line, the first line of clause 55.
oh,
Now, in an exchange with Mr. Futrell, you drew the well-known distinction between governance and management. I think you said it was in the context of the board has to walk the talk, be visible, but not trespass in management. So the clear distinction, or clear has, that's probably one of the problems. The distinction between governance and management, that the governors govern and the managers manage. Now, against that, do I understand, because I'm not asking you for a legal interpretation of clause 3.12, but do I understand from the first line of clause 55 that the distinction there is that you're talking there about management as opposed to governance, that the central management and the day-to-day control of the business resides in Perth?
yes, but I haven't commented on governance.
No, that's what I'm asking you. Is that are you concentrating there on saying that it's the management that must be in Perth, and therefore what might go on top of that in terms of governance is not the control of that is not sensitive. That is not geographically sensitive.
No, this is commenting on management, as you correctly identify, Commissioner. Then the draft charter is quite specific in the need for the board to meet in Perth, to have an independent director in Perth, to show a tie to Perth. So aspects of the governance go to the parent, but as I said, Burswood Limited will operate as a subsidiary, but with a full set of board meetings and a full set of governance. So that will happen in Perth. Again, consistent, for instance, with my example that I used with Genesee and Wyoming, where that's the way we operated separately from a parent that lived in Connecticut.
Right, thank you. Anything arising, Mr. Futrell? Ms. Thornton.
No re-examination, thank you.
Right, thank you. Mr. Carter, thank you very much for making yourself available and for your time and for your evidence, which has been of assistance to us. We are grateful for that. Because the situation is still pretty fluid, I think we might leave the summons in place. The likelihood of us wanting to speak to you again is not great, but just in case, and you'll be advised as soon as we're able to discharge the summons. I'm free to go, and again, thank you very much.
Thank you, and understood, Commissioners.
And we will adjourn. I'm sorry, just one last thing in closing. Early in your evidence, you said that you were rather surprised at the amount of time that your directorial duties have taken up. You perhaps underestimated it. I think that's what you said, isn't it?
In Crown?
In Crown? You don't. A yes or no will do.
The answer is yes, I was surprised. It's not many boards meet 3 times a week.
I just wanted to say that probably in this room there's a lot of sympathy for that view. And we'll now adjourn to Monday at 10 a.m.
All rise.